You are listening to Based in Fact, a true crime podcast. Join hosts Lisa O'Brien and Kyle Evans as they examine America's most infamous true crime cases as they were established in our courts and the basis for the decisions of the appeals courts, not the court of public opinion. Here's Lisa and Kyle.
Welcome to Season 4 of Based in Fact, a true crime podcast. We're your hosts, Lisa O'Brien and Kyle Evans, and this is Episode 3, Updates. We are going to talk about the developments and cases we've covered in Seasons 1 through 3, including Oklahoma versus Richard Glossip, Oklahoma versus John Fitzgerald Hanson, Maryland versus Adnan Syed, Arkansas versus Echols, Baldwin and Miskelley, Texas versus Rodney Reed, and Texas versus Melissa Lucio. Then we are going to look at the proposed schedule for Season 4 and some of the episodes that we've planned. And good afternoon, Kyle.
Good afternoon. That's like an all-star lineup of true crime right there with those cases.
Yeah. And there are some cases that aren't even going to be mentioned because there's literally nothing has happened since the last time we talked about them. So it's not going to be, I think, as onerous as our prior update episodes have been, because I'm not trying to mention every single solitary case we've covered.
Makes sense.
And then, of course, I'm in New Orleans, so we are in the final stretch of Mardi Gras.
Oh, yeah, that's right.
We have Bacchus tonight, and then tomorrow and Tuesday are the big show. I was lucky enough to be able to take off work for those days, so I get to sleep in and have a 4.5-day weekend.
Excellent.
So we could have done this tomorrow if we really had to. But I was able to finish my notes yesterday, patting myself on the back for that. All right, so let's get started. And of course, the biggest development, and the one that irks me the most, is Oklahoma versus Richard Glossip. The victim in that case, Barry Allen Van Treese, age 54, was murdered on January 7th, 1997. Glossip's first conviction was reversed and remanded for a new trial in 2001. So the news outlets that are saying he was convicted in 1998 are either not being honest or not smart enough to figure out the true procedural history of his
Yeah,
case.
it's probably just laziness. I think that's the big thing. I mean, that's a whole other episode, but I think one of the things we suffer is from a culture overall is just the poor quality of journalism these days, where rarely do we get them to actually do any legwork.
Yeah. So anyway, then he was retried in June of 2004. He was found guilty of first-degree murder, malice murder, and was sentenced to death. His direct appeal, the conviction and sentence were both affirmed on April 13th, 2007, and his writ to the U.S. Supreme Court was denied on January 28, 2008. So his conviction and sentence became final in 2008. He has had several state post-conviction writs, and they were all denied. I'm not going to go through each and every one. But beginning in 2015, he had a new attorney named Don Knight, who was starting to invent all these stories about Justin Sneed and was looking for a Brady violation or a constitutional violation to get to challenge the conviction. And unfortunately, their creative writing skills finally earned them what they wanted, which is an unjust result. But anyway, spoiler alert. He had federal habeas claims, which were denied in 2010 and affirmed in 2013. He has had multiple writs to the U.S. Supreme Court. They were either denied or his one challenge to the use of midazolam was affirmed. He has I'm going to skip over some of this stuff. He was scheduled for execution in 2023. Clemency was denied. He has 2 pending writs at the U.S. Supreme Court. One of them challenging state court denial of his 2022 state post-conviction writs, which were denied. And then in 2023, challenging another writ that was denied. And that one was supported by the Oklahoma Attorney General, who decided to abandon the family of Barry Van Treese and advocate for Richard Glossip. And I hope that decision bites him in the ass when he runs for future political office. From what I understand from some Oklahoma people, that is what is going to be the case. So, again, spoiler alert, I'm not happy about this at all. Glossip's May execution was stayed by the U.S. Supreme Court. So now we get to the update. His first writ is still pending. The writ has not been granted, and no dismissal of the writ has been entered, which is a housekeeping thing that they probably are going to have to do shortly. Then there's also an ancillary action. There's a dispute between Kevin McDougal, who also chose to advocate for Richard Glossip, a guilty murderer, and Jason Hicks, an Oklahoma State prosecutor. That action, it's a dispute over production of public records. That was dismissed on summary judgment at the behest of Mr. Hicks. And that is on appeal now at the Supreme Court of Oklahoma. So I'm just going to skip over all that. But basically, the summary judgment was granted because the plaintiff's claims, their assertions and their claims were insufficient to create a genuine issue of material fact that would require the court to proceed any further. Then on August 19th, 2024, in Glossip versus Oklahoma, the joint motion of petitioner and respondent for divided argument is granted, but the court denied Derek Van Treese's motion for leave to participate in oral argument, which I think was wrong. And of course, in this particular case, Justice Neil Gorsuch cannot participate in any decisions as to Glossip because of his former position as a judge on the 10th Circuit Court of Appeals, which decided prior Glossip cases. And they had oral argument for the case in 2024 in October. And then on Tuesday, February 25th, the U.S. Supreme Court reversed and remanded Glossip's conviction. Basically, they held that a note that was allegedly not provided to the defense regarding statements made by Justin Sneed to the prosecutors invented NAPU violation. And so they reversed on that basis. And I'm not going to go through their holdings, but I do want to go through the dissent. There was one authored by Justice Barrett and a second one authored by Justice Thomas. And Justice Barrett concurred in part and dissented in part. She said, "Well, I agree with much of the court's analysis. I would not order the Oklahoma Court of Criminal Appeals to set aside Richard Glossip's conviction. The OCCA did not make factual findings on the most important questions, and the record is open to multiple plausible interpretations. Consistent with our ordinary practice, the court should have corrected the OCCA's misstatement of Napio versus Illinois and remanded this case for further proceedings. Instead, the court has drawn its own conclusions about what the record shows, thereby exceeding its role. And then she goes into why she disagrees. And basically, she states, I respectfully disagree. Smotherman's notes taken during a jailhouse interview of Snead consist of the words "on lithium?" and "Dr. Trumpet?" These notes are hardly clear, and there are competing explanations of what they mean. Glossip, the Oklahoma Attorney General, and the court argue that they demonstrate Smotherman's knowledge that Snead had lied about Dr. Tromka's prescribing him lithium for bipolar disorder. The Ventris amicus brief and Justice Thomas contend that the notes instead reflect Snead's account of a conversation with Glossip's lawyers who had asked Snead whether he had received lithium from a Dr. Trumpet. There are other possibilities too. For instance, perhaps Smotherman was confused by references to Dr. Trumpet and lithium, but never investigated the issue further. Neither Dr. Tromka's affidavit, nor the attached medical information sheet, nor any other record evidence discussed by the court forecloses any of these possibilities. When the record is susceptible to multiple plausible inferences, this court should not be in the business of choosing between them. It should have corrected the OCCA's misstatements of federal law and vacated the judgment, leaving next steps, including the decision whether to conduct an evidentiary hearing, to the OCCA. By doing otherwise, the court has both displaced the OCCA as fact finder and potentially overridden state law constraints on the OCCA's remedial authority. Because the court has exceeded its appellate role, I respectfully dissent in part. And then Justice Thomas has an even longer dissent, and he does not mince words. He says, Richard Glossip, a convicted murderer twice sentenced to death by Oklahoma juries, challenges the denial of his fifth application for state post-conviction relief. Although Glossip won the support of Oklahoma's new Attorney General, he failed to persuade either body with authority to grant him relief. The Oklahoma Court of Criminal Appeals denied Glossip's application as both procedurally deficient and non-meritorious, and Oklahoma's Pardon and Parole Board denied clemency. Because this court lacks the power to override these denials, that should have marked the end of the road for Glossip. Instead, the court stretches the law at every turn to rule in his favor. At the threshold, it concocts federal jurisdiction by misreading the decision below. On the merits, it finds a due process violation based on patently immaterial testimony about a witness's medical condition. And for the remedy, it orders a new trial in violation of black letter law on this court's power to review state court judgments. I respectfully dissent.
Do you know, you mentioned it earlier, do you have a sense, we probably talked about it on the original episode, but why the sudden interest in his case? I mean, why is there that, I think it was a state senator that sort of picked up his cause? Is there any sense on what's behind that?
What is behind that is Don Knight has pulled the wool and put on his dog and pony shows about Justin Snead to the legislature, and they have allowed him to do that without respectfully going to the prosecutor and asking for the same presentation from the prosecutor. Basically, they take Don Knight's dog and pony show at face value, and then they go to the prosecutor and say, prove him guilty. And when the prosecutor says, fuck you, which is probably what Mr. Prater said, were probably Mr. Prater's exact words, because he is a little firecracker, they say, oh, well, he must not be guilty then.
And to remind everyone, Don Knight is, he just has kind of own one-man Innocence Project, that this is kind of his shtick.
No, I don't know. I guess Don Knight has a lot of money to throw around. And I think that that's another thing is Don Knight has offered political support to Drummond and to probably Rex Duncan and to Humphreys. Now McDougal's out. McDougal's political career, I hope, is over for good. I think
Gotcha.
Humphreys is still at the legislature, but hopefully his days are numbered as well. And then I want to go on. Thomas's dissent continues. After having bent the law at every turn to grant relief to Glossip, the court suddenly retreats to faux formalism when dealing with the victim's family. The court concludes that it need not honor the family's right to be heard because the family did not request an evidentiary hearing earlier in the proceedings. But the family had no need to do so since Glossip had conceded that a hearing is necessary for his claim to rise above the level of speculation. And that's motion for evidentiary hearing. And before this court, the Van Trees family has vigorously asserted its interests. The family filed the only brief opposing certiorari in this case. See brief for victim family members. It filed a merits brief highlighting critical evidence that the parties sought to sweep under the rug. And it filed a motion to participate in oral argument, which this court denied. The majority's assertion that the family has sat on its rights is groundless, nor is there any reason to believe that Oklahoma victims' rights to be heard in any proceeding contains an implicit exception for post-conviction hearings. Finally, even if the family had no formal right to be heard, any reasonable fact finder plainly could consider the account of the evidence that the family has brought to light, making the majority's procedural objections beside the point. Make no mistake, the majority is choosing to cast aside the family's interests. I would not. Finally, he says, the court's decision distorts our jurisdiction, imagines a constitutional violation where none occurred, and abandons basic principles governing the disposition of state court appeals. I respectfully dissent. And I couldn't have said it better myself. So this is where we stand. Apparently, there is a grassroots effort being launched to ensure that Glossip is retried. Unfortunately, the prosecutor in Oklahoma County has previously said she wouldn't try him.
So she would just let him out, just like she just release him.
Yeah. And now there is also, although it's unlikely to succeed, there is also a petition for rehearing that could be based on Justice Barrett and Justice Thomas's comments regarding the court exceeding its jurisdiction. It's possible that maybe if this was a 5-3, because Justice Alito, Justice Thomas, and Justice Barrett dissented. So it's entirely possible if they could convince one justice, if there's a rehearing and they can convince one justice that they're exceeding their authority, then it could become a 4-4. To send it back correcting NAPU and let the Oklahoma Court of Criminal Appeals actually decide whether there was or wasn't a NAPU violation, because they summarily dismissed, which would give everybody a chance to develop the evidence and to show that the notes are not what Don Knight and Rex Duncan and Gentner Drummond have lied to the public to say that that's what they're about. But I don't know if that's going to happen. And I don't know if that's going to be, because I don't know if the appointed amici, the appointed attorney appointed to defend the conviction will take that step. And it's got to be them. It's got to be him to take the step.
Right.
But yeah, it's right now it's kind of up in the air. But I hope they retry him. And a lot of the stuff they want to bring in about Justin Sneed, they're not going to be able to bring it in. Well, and that's hearsay, and it's hearsay, and it's witnesses who who probably will not appear at trial, and if they do appear at trial, their credibility is going to be totally destroyed.
Well, and it's hard too. I mean, that's why all these, if you can ever try to it's really hard to try a case
Yeah,
again, and it's hard to try a case, decades later. I mean, memories fade, people die, so I bet the Oklahoma DA is just like, yeah, I don't want to mess with it. It's not gonna. I've got more stuff to worry about. Kind of
well,
like what
hopefully
happened in
they,
West Memphis.
like I said, well, but that was not, but that was when the killers brought the Alford plea. And yeah, he was too fucking lazy to say, well, let's wait and see what happens at these
Right.
hearings. But this is a little bit of a different thing.
Right, but I think the whole thing of just I mean, if you think about it, I think about DAs. I mean, they're good people, but they generally want to do what's right and they want to get elected. They often
Yeah,
have limited resources, and they're like, okay, do I go retry this decades old case where there's not going to be that much outrage about it versus
yeah.
spending time on a murder that happened in 2023.
So, all
They
right,
should. I just don't see them doing it.
right.
Because it just
It's
encourages this kind of
it's gonna
behavior.
it's gonna be very disappointing, and this is already hurting. I mean, in addition to the Van Treese family, there are a couple of other people who had experiences with Glossip, and this has hurt them. And I feel really horrible for them because, but I'll call him a murderer to his face, and he wants to do anything to me, let him come, and I'll
Well,
take him
yeah.
out.
Yeah,
You
I
know,
think yeah,
he'd be messing with the wrong person. But well, whatever. So, and I will call him a murderer. He's a murderer. He is a murderer. And if they want to sue me, let him sue me. And then there's going to be a whole lot of evidence from his trials that's going to come back to bite him in the ass. All right. So now we move on. Oklahoma versus John Hanson, aka George John Hanson. His victims were Mary Agnes Bowles and Gerald Thurman, who were killed on, who were shot on August 31st, 1999. Hanson carjacked Miss Bowles and then was on Thurman's land and encountered Thurman and shot him, or his co-defendant shot Mr. Thurman. Ms. Bowles likely died on August 31st, but her death date is listed as September 7th, and Mr. Thurman did die on September 14th, 1999. Hanson was found guilty on May 22nd, 2001 of first-degree malice murder of Mary Bowles and first-degree felony murder of Gerald Thurman. He was sentenced to death on the murder of Mary Bowles and life on Gerald Thurman. His convictions were affirmed on June 11, 2003. His life sentence was affirmed, but his capital sentence was reversed and remanded. He was resentenced to death on January 24, 2006, and that sentence was affirmed on April 13, 2009. His writ to the U.S. Supreme Court was denied on December 7, 2009. He has had 3 state post-conviction claims. They were all denied, including a claim that he is a member of the Cherokee Nation or Muskogee Cherokee Nation, and therefore was exempt from prosecution in state court. That was denied in 2021. He has had a federal habeas petition denied in 2013, and that was affirmed in 2015. He has appealed twice to the U.S. Supreme Court, both of which were denied for his federal habeas challenge and his McGirt challenge, which is the Indian. Either he's a member of the Indian Nation, the victim's a member of the Indian Nation, or the crime took place on Indian land. Although I think that their claims that the crimes took place on Indian land are somewhat, let's see, speculative.
Well, and that could be a whole other episode. Like, I don't fully understand kind of the McGirt and all the details of, you know, what can happen, can't happen on Indian land or not.
Mhm.
It's
Well, yeah, and it's basically there is a federal statute, but it's from the 1800s that prohibits prosecution of Native Americans for crimes committed on Native land,
but what
and
is
saying
that
that that's got to be
actively in
entirely federal.
got it. Yeah, and I won't chase the rabbit, but that seems crazy. I mean, that basically gives almost a free hand to commit crime. If
Well,
you're an Indian on Indian land, you can just
at
do whatever you want.
at the time, well, no, but at the time, um, in individual states with native populations, there was a lot of prejudice against the
Right.
native population or indigenous population, whatever you want to call it, whatever the politically correct terminology may be now. And so moving it to federal court was thought to be a neutral forum.
Yeah, that makes sense.
And I believe that this was at a time when the federal courts actually governed everything to do with indigenous people and land and their lives. So he had an execution date set in 2022, but
Sorry.
the federal authorities refused to transfer him back to Oklahoma. That was challenged in the state of Oklahoma et al. Versus Tellez. And on the 13th of December, the court denied the motion for preliminary injunction and dismissed the case for lack of jurisdiction. And a judgment was filed on December 16th, which was final because it was not appealed. And Hanson's execution date of November 10th, 2022 expired. And at the time of our last show about this case, no new date had been set. How things have changed and fortunes have reversed for poor Mr. Hanson.
And hey, real quick, do we know, did he actually prove like legal documentation that he was a member of a tribe, or did he just make that claim spuriously? Because
he provided documentation that declares him to be a member of the nation.
Gotcha.
And he provided documentation that the land that they were on was somehow part of. Well, he claimed it was part of a reservation, but I don't believe that that's the case.
Gotcha.
Because that belonged to the Thurmans, unless the Thurmans were living on Indian reservation. I don't know.
Yeah,
I don't think so. I'll have to look I'm going to look into that. We'll talk about McGirt when we do our USSC case review. I will make sure to include McGirt.
Got it. Yeah, I find myself driving through Oklahoma frequently these days, and there are, basically half the states, the Muskogee or Choctaw tribes.
And a lot of Seminoles ended up there.
I was laughing, like, does that mean I don't have to pay it if I get a speeding ticket? I don't have to pay it.
I don't know. I really don't know about that.
I know. I won't chase the rabbit, but I was actually, we were thinking about that during one trip.
If you get a speeding ticket and you don't pay it, you can't go through Oklahoma ever again.
Well, it used to be, I won't name a state, but it rhymes with Louisiana. They used to just hold you in the county jail till you paid it in cash.
Well, that happened to my father. I think in North Carolina once.
Yeah, that used to be the joke when I was a kid. If you got a ticket in Louisiana, they just take you to jail until you paid it.
Yeah.
If you were from out of state.
Well, I mean, no, that happened to my dad. He got pulled over for speeding in North Carolina, and he got into the car with the officer, and then we had to follow them to the little town, and he had to pay the ticket then. And my sisters and I, we were little girls, and we freaked out when Dad got into a police car. Now,
Yeah.
he was in the front seat, and he wasn't cuffed,
Well, that's at
so
least
that was good.
considerate.
And he luckily, you know, uh, he did not act like the captain of a ship with that police officer,
Yeah.
because that could have turned really bad really quickly.
Right.
And my mom did not get out and try to help him.
Yeah. It's just like take
But
your
when
fine
the
and
car when Dad got in the car and the car pulled off, one of my sisters freaked. And I mean, she was inconsolable. She thought Daddy was gone forever. And Mom just got into the driver's seat, and we followed into the town and took care of everything. We were back on the road within an hour. But so yeah, luckily there was like a justice of the peace or somebody there who could deal with it on a Saturday.
yeah, I'm sure he was really excited to, get off his fishing boat and have to come in and roll on your dad.
Yeah,
That's
well, this
funny.
is the 70s. I think they probably had somebody that like had duty,
Yeah, no, I'm sure. I'm just
because
chuckling
this
at.
was the 70s. There were no cell phones. If he was on a
Yeah,
fishing boat,
exactly.
nobody was going to get him, absent getting on a boat and go out and dragging him back. So, all right. So, fortunes have changed for Mr. Hanson. So this is not entirely a bad news show. Um, on May 7th, 2024, um, there was another order from the state Oklahoma Court of Criminal Appeals regarding setting of execution dates, in which Hanson's case was one of those mentioned. But they denied the state's motion to set phase 3 execution dates as a group, and they ordered that they would set execution dates one at a time and will implement each of the above recommendations when scheduling execution dates unless circumstances dictate modifications as to the interval between execution dates. And that's DOC wants a minimum of 35 days notice before a scheduled execution, and executions occurring at approximately 90-day intervals. On January 20th, 2025, our incoming president, Donald Trump, issued an executive order titled Restoring the Death Penalty and Protecting Public Safety. On January 23rd, 2025, Gentner Drummond sent a letter to the U.S. Department of Justice, Federal Bureau of Prisons, requesting that Hanson be transferred to Lexington Assessment and Reception Center in Lexington, Oklahoma, in advance of the state's next execution date of March 20th, 2025. On the 29th, Hanson filed a petition for declaratory judgment, seeking to block his transfer from federal prison in Louisiana to Oklahoma. His causes of actions were that his transfer to Oklahoma would not serve the public interest because it would deprive the federal government of its right to exercise primary jurisdiction over Hanson and constitute an unwarranted state interference in federal sovereignty. It argued that he was a member of the Muskogee Creek Nation and the crimes for which he was convicted occurred on the Cherokee Nation Reservation in Oklahoma, which is questionable. The Major Crimes Act mandates exclusive federal jurisdiction of named serious crimes that was enacted in response to Ex parte Kanji Shun Ko, otherwise known as Crow Dog, and that's a U.S. Supreme Court case out of 1883, which held that only the tribe had jurisdiction to try an Indian for the murder of another Indian in Indian country. Congress eliminated the death penalty for federal prosecutions of Indian defendants under the Major Crimes Act unless the tribal governing body consented to its imposition for a crime committed on its Indian country. A decision to release Hanson to state custody is made against the express wishes of the Cherokee Nation, the nation on whose reservation the crime was committed, and against the Muskogee Creek Nation, the nation to which Hanson belongs. The resulting imposition of the death penalty upon release to Oklahoma is a betrayal of a promise made to the Cherokee and Muskogee Creek nations, and it demonstrates deep disrespect for tribal sovereignty. And that one, when I typed that one struck me as kind of irony challenged, because one of the big claims, and not not without justification, is that the U.S. government has not kept a lot of promises it has made to various indigenous populations and tribes. And so, how is this one any worse?
Yeah, we don't have a great record of keeping our word.
And then the third, the BOP is only required to transfer a qualifying prisoner prior to his release from a federal prison facility, and there is no prospect of Hanson being released from federal prison. Hanson prayed for an order enjoining Hanson's transfer to Oklahoma until he has completed his federal sentence. A preliminary and permanent injunction enjoining Hanson from being transferred to the state of Oklahoma. An order enjoining Hanson's transfer until the matter can be fully briefed and resolved by the court. And this was filed in the Western District of Louisiana, by the way. An order directing Director Goldie to secure physical custody of Harris, a declaration that defendants are unlawfully seeking to transfer Harris under 18 U.S.C. 3623, which is, I believe, the Major Crimes Act referenced above, and grant such other relief as the court deems proper. Now, on January 31st, the magistrate issued a report and recommendation granting the motion for temporary restraining order in part to the extent it seeks an order prohibiting Hanson's transfer to the state of Oklahoma until such time as the parties in opposition may be heard and the district judge may conduct additional proceedings in his discretion. It was further recommended that the Bureau of Prisons be temporarily enjoined and prohibited from transferring Hanson to the custody of the state of Oklahoma or any other entity's custody pending further orders and proceedings to be determined by the district judge. And it set a due date for objections to the report and recommendation of February 14, 2025. Summonses were issued to all defendants. In the federal defendants, on February 5th, 2025, Attorney General Pam Bondi, I'm probably mispronouncing her name. She issued a memo to from her office reviving the federal death penalty and lifting the moratorium on federal executions. And that is to be consistent with President Trump's executive order. She ordered the lifting of the moratorium on federal executions, seeking the death penalty in federal prosecutions, reviewing no-seek decisions since January 20th, 2021, strengthening the federal death penalty, and assisting the implementation of state and local death sentences. On the 6th, a summons was issued to Attorney General Drummond. On the 11th, 2025, a second memo was issued by the Office of the Attorney General, memorandum for the acting director of the Federal Bureau of Prisons, and the subject was transfer of inmate George John Hanson, aka John Fitzgerald Hanson, to the custody of Oklahoma to implement a sentence of death. And basically stating the timely enforcement of inmate Hanson's death sentence will achieve justice and provide a measure of closure to the victim's family and her community for the horrific crime committed by inmate Hanson. The Department of Justice owes it to the victim and her family, as well as the public, to transfer inmate Hanson so that Oklahoma can carry out this just sentence. On the 12th, a response of the United States and federal defendants to the motion for emergency relief and objection to the magistrate's report and recommendations was filed by the federal defendants, who said that Hanson was unlikely to succeed on the merits because he had not identified a waiver of sovereign immunity. His attack on the validity of his state conviction is cognizable only under habeas statutes and not here. A decision to transfer a federal prison to a state authority under Section 3623 is not subject to judicial review, and his transfer meets the statutory requirements of Section 3623. It also argued that he failed to satisfy any of the remaining factors. On the 13th, Drummond issued a press release that announced AG Bondi's agreement to Hanson's transfer to Oklahoma. On the 18th of February, Drummond did file an objection to the report and recommendation. He argued that timely justice for victims, their families, and the community is in the public interest, and any injunctive relief would have an intensely adverse effect on the interest here. Several procedural aspects of this case are troubling, and I believe that that's referring to Hanson's petition. And plaintiff failed to disclose his unsuccessful attempt to raise McGirt in state court. Drummond filed a motion to supplement, seeking to add a signed declaration that was not available on the 18th at the time he filed his objection. That was granted on February 24, 2025. And the signed declaration of the prosecutor in the case. They also included a declaration or affidavit from a family member of Mary Bowles with their objection. Hanson filed a response to the objections to the report and recommendations on the 25th. On the 27th, the judgment was entered by the court. Before the court is the magistrate judge's report and recommendation pertaining to plaintiff John Fitzgerald Hanson's motion for temporary restraining order. For the following reasons, the report and recommendation is not adopted. Hanson's complaint is dismissed without prejudice as unripe, and his motion for a temporary restraining order and preliminary injunction is denied as moot. And then as of yesterday, Hanson was still at USP Pollock, which is in Louisiana. However, last night, Hanson was transferred to Oklahoma. So he's back in Oklahoma as of today.
Does he have it? Sorry, does he have a date set? Did you mention that?
No, he does not have a date set yet. Now that he's back in Oklahoma, and in reality, and I may or may not have said this when we talked about Hanson initially, they really should have sought his transfer and then sought a date rather than getting a date and then asking him to be transferred.
Gotcha.
But either way, the federal government would not have transferred him to, but if they had agreed to transfer him, then, they could have executed him in 2022.
Right.
But with him having an execution date, the Biden administration was not going to let anybody be executed. So that is that case, and we will, of course, look at it again. I'm sure he'll probably, his petition was denied without prejudice or dismissed without prejudice, which means he can refile it. But he's going to have to come up with some actual legal arguments, not the ones that he tried initially, because they weren't sufficient. So, but no, it's likely his date will be set in June. There's an execution set in March on the 20th. So the next date would probably be June. And I read one of the articles said around June 12th. So we'll have to wait and see. But I will, and of course, I'll update like things like that at the beginning of, subsequent episodes. And then maybe we'll look at his case again prior to the next date. All right, so our next case is Maryland versus Adnan Syed, which we covered with the late and sorely missed Rob Chadwick. The victim in that case was Heyman Lee. She was murdered by Adnan Syed on January 13th, 1999. His first trial ended in a mistrial when the judge called Gutierrez a liar in front of the jury, which I still kind of suspect that she was pushing buttons to try and achieve that outcome, based on what I've read about the incident itself. He was tried a second time in 2000, and on February 25th, 2000, he was convicted of first-degree murder, robbery, kidnapping, and false imprisonment. And there was a judgment of acquittal entered on the robbery, and a null prosequi entered on his accessory after the fact robbery count and the counts 2 and 3 for robbery of him and Lee. He was sentenced on July 28, 2000 to life plus 30 years. That was not a mandatory sentence. That was after a sentencing hearing where the judge analyzed Syed's presentation of mitigating factors and the state's presentation of aggravating factors. But he was 17 at the time he committed this crime. A few months shy of his 18th birthday.
Yeah, that's right. I'd forgotten about that.
His direct appeal, his conviction and sentence were affirmed on March 19, 2003. His writ to the Maryland Court of Appeals, which was at that time was Maryland's highest court, was denied on June 25th, 2003. He had 2 state post-conviction actions. Relief was denied on his first, but it was granted on his second in 2015, and his conviction was vacated and a new trial was ordered. However, on appeal, that was affirmed in part and denied in part, and his conviction was reinstated. Reversed and the case was remanded. And basically the court held that the trial counsel's performance was deficient, but Syed failed to demonstrate prejudice or that Asia McClain's testimony would have changed the outcome of the proceedings against him. The cell phone tower location claims were waived because they could have been raised in the first ineffective assistance of counsel petition. In 2019, certiorari to the U.S. Supreme Court was denied. Then there was agreed DNA testing in 2018, which I should have moved. That testing, the results were inconclusive. On the 22nd, or March 14th, 2022, a joint petition for DNA testing was entered. The results of that testing were not released to the public, but at that time, the state's attorney's office claimed that Syed was excluded by DNA testing. The only detail they gave was that the shoes found in Hay's car yielded a mixture of DNA from 4 people. They said Syed was excluded. They failed, I believe, to mention that so was Hay.
Yeah, I mean, it's just who knows? So it could have been a friend of hers that left the shoes in the car. I mean,
right. They could have
crazy.
belonged to somebody totally different. And now I'm seeing posts on Twitter and Facebook. Well, did they swab the inside of the shoes to get her DNA from there?
I'm still amazed anybody believes the Asia McClain story. Like, I'm just shocked that how, like, people are just so committed to one side or the other. They literally act completely illogically to just make sure their tribe wins.
So on September 14, 2022, the state attorney's office filed a motion to vacate Syed's conviction pursuant to Maryland Code annotated 8-301.1. Syed filed a response to the motion to vacate on the same day, joining the SAO's request for release. So if you don't believe a fix was in, then you're delusional.
Oh, totally.
The court entered an order on September 16th, 2022, setting the hearing on the motion for September 19th, 2022. On that same date, the court also held an in-camera hearing at which evidence was presented without the presence of the victim's family member and off the record.
Yeah, that dingbat district attorney was so disrespectful to the Lee family. I mean, we've rarely seen victims being treated that way by that dingbat, but fortunately, I think she lost.
In some ways, though, I think that as painful as it was for the Lee family and a lot of people, it made the whole motion to vacate null and void. If they had followed proper procedure and his conviction had been vacated, and then the state's attorney had decided not to retry him, so he had effectively been declared innocent, there would have been no way to appeal it.
Right.
It would have been a done deal, final but like I said, the fix was in. And that's why there's a security and media order issued on the 17th for the vacatory motion hearing set for 9/19. Young Lee on the 19th, attorneys on behalf of Young Lee filed a motion for postponement and demand for rights, requesting a 7-day continuance to allow Lee to travel to Baltimore, attend the hearing in person, and seeking unspent victim and witness relocation funds from the SAO's office to pay for his travel to Baltimore. And again, I see a lot of people saying, well, he knew a day before. He can get on a plane the day before. Well, not if he has to work. Not if he has, not if he has to get permission from his employer.
Yeah,
And
that's a stupid comment. That just shows you how hateful people are. How they're so, all the, what I call them, these, killer fanboys, they just worship these killers so much they could care less about victims' family, and honestly also treat them like crap.
So, and if you want to be mad at somebody about all that, be mad at Marilyn Mosby and Judge Finn. Because if they had followed proper procedure, it would have been a done deal and nobody could have said anything. But because they were so arrogant and thought that they didn't have to follow this procedure,
right?
They're the ones that doomed it to failure, ultimately.
Which that was Mosley's resume, a mix of arrogance and unbridled stupidity.
Yeah. So the hearing was held on the 19th. Of course, the motion to postpone was denied. Lee was able to attend via Zoom. His attorney was permitted to make a brief statement, but then the motion was argued, and Judge Finn read from a prepared order, which included Syed's immediate release, and then released the parties to attend a prearranged press conference. So anybody who does not believe the fix was in
Right.
is delusional, because we'll talk about the latest hearing in a moment. That is how this one should have gone. The order was entered on the 19th, and on the 11th of October, based on the alleged exclusion by DNA, which is not really as strong as Mosby claimed it to be. The charges were null pros, so Syed became an innocent man. On the March 28, 2023, however, the judgment of the Circuit Court of Baltimore was vacated by the Court of Appeal in Maryland, and the case was remanded for further proceedings consistent with his opinion. The costs were to be paid 50%, assessed 50% by the mayor and city council of Baltimore, and 50% to Syed, which means Young Lee was right. His position was right. His appeal was meritorious. On May 2nd, 2023, Syed's motion for reconsideration was denied. A writ of petition for writ of certiorari was filed to the Maryland Supreme Court. That was granted. And on August 30th, 2024, the judgment of the Appellate Court of Maryland was affirmed in part and reversed in part. The case was remanded to that court with direction. The mandate for that issued on September 30th, 2024. That became final on December 30th, 2024, because Syed did not appeal the Maryland Supreme Court's decision to the U.S. Supreme Court. But on the 23rd of December, 2024, Syed filed a motion for reduction of sentence pursuant to the Juvenile Restoration Act. And listeners, if anybody has a copy of that motion, I would love to get my hands on it. I would love to see what his claims were, etc. Because I've seen a lot of claims about how he had a perfect record in prison, but I've also seen that he's bragged about breaking the rules in prison and having things like illegal cell phones. So anybody who has a copy of that motion, I would love a copy of it, because I would love to to see what the grounds and the basis for it were. The young Lee's family on the 10th filed a motion to stay consideration pending a decision by the state attorney's office on whether or not to redo the motion to vacate. And asking for additional time if the court was not going to stay consideration to give young Lee a chance to file an opposition to the motion to reduce sentence. On the 12th, the state's attorney's office filed a response to the motion for reduction of sentence, which basically supported Syed's request. On the 10th of February, 2025, an order was issued setting the hearing on Syed's motion for sentence reduction for February 26, 2025, which were dates provided by both young Lee's family and or Heyman Lee's family and the state's attorney's office as being dates that they were available, which is another thing that did not happen with the motion to vacate. Because the state's attorney actually reached out to young Lee's family or Heyman Lee's family and said, hey, when can you appear for the hearing? And there was 16 days between the date the order was set and the hearing itself. A press release was issued on February 25th, 2025, the day before the hearing, in which State's Attorney Ivan Bates said, after a thorough review of the motion to vacate judgment filed by the previous administration in the case of Adnan Syed, my office has determined that it contains false and misleading statements that undermine the integrity of the judicial process. As prosecutors, our duty is to seek justice and ensure that all legal proceedings are conducted transparently, accurately, and fairly. While I did not ask for this task, it was remanded in my office by the Supreme Court of Maryland. Thus, we have a duty as Maryland barred attorneys and prosecutors tasked with pursuing justice and officers of the court to address false and misleading statements in the state's legal filings, a duty that we take extremely seriously. As such, we cannot adopt the falsehoods and misleading statements in the motion to vacate judgment, nor fail to bring them to the court's attention. For these reasons, I formally withdraw the motion to vacate judgment. I did not make this decision lightly, but it is necessary to preserve the credibility of our office and maintain public trust in the justice system. My administration remains fully committed to reviewing cases where wrongful convictions or miscarriages of justice may have occurred. However, we will do so with the highest standards of integrity and a commitment to truth. I recognize the complexity and sensitivity of this case. I hope this comprehensive review and my ultimate decision to bring closure to all parties involved. And then he had an executive summary, which was very critical of the motion to vacate and some of the statements made in it. And it is available online to read. But one of the interesting statements he made is, as a final note, Ms. Mosby represented to the court that this was an open and ongoing investigation. This office's review of this matter has not revealed that there was ever an open investigation into any purported alternative suspects in the murder of Heyman Lee. BPD similarly reported that it did not have an active investigation, and this office will not ask for one to be opened. So that's the end. The state's not going to pursue the motion to vacate. There's an 88-page memorandum, which, again, is available online, and it's a great read because it really takes apart that motion to vacate and all of the allegations made in it by the Marilyn Mosby's office and her conviction review team.
Which probably none of them actually ever went to law school.
Well, no, I think that what happened was she filed a lot of former innocence. She hired a lot of former Innocence Project attorneys.
Yeah, I know. I was just kind of being snarky.
I know.
She's one of the worst. What? So where do we stand now? He is out of prison, right?
Well, okay. That's where we're getting. There was a hearing held on February 26, 2025, where the court is going to consider his motion for reduction of sentence. What he's seeking is that his sentence be reduced and that he be given time served. and that he be allowed to remain free without any kind of probation or parole considerations or conditions. The state attorney supports that. I don't believe the Lee family, I don't believe they actually filed an opposition, but they did appear at the hearing and they did oppose that in their testimony at the hearing. The judge has taken the matter under advisement and she will issue a decision sometime within the next couple of months. It may be a few weeks. It may be a few months.
Right.
But that is how the motion to vacate should have gone.
But at the end of the day, there's a very low probability he'll actually serve his full sentence.
It's possible. I mean, this judge, based on based on the Lee family testimony and his failure to take any accountability or responsibility, because he's now gone before the court as the guilty person. So instead, and he hasn't taken any accountability. He's still claiming he's innocent. He didn't do this.
Right.
So the court may say, well, I'm gonna reduce it from life, but I think he needs to do some more time.
Yeah, that would be just, but I feel like, I don't know, I'm too cynical. I think it's one of those, it's way too hot for this judge to do the right thing, which would be perceived as quote unquote controversial.
Well, Ivan Bates did the right thing. He dropped the motion to vacate or withdrew the motion to vacate.
That's fair. Well, I certainly hope you're right.
So, it's like I said, I mean, with him being out for the 2 years, 3 years now, 2.5 years maybe, I don't know. But again, I mean, she could reduce it to something less than life where he would be eligible for parole.
Right. Like reduce it to 60 years or something.
And she could also say time served, but then set some parole conditions. So he would have some supervision.
Right.
And then, he's got to keep his nose squeaky fucking clean or he's going to go back to prison. So, but we'll have to wait and see. All right. Our next case is Texas versus Robert Roberson. The victim in that case was Nikki Michelle Curtis Bowman. She died, or her injuries occurred on January 30th, 2002, but she died on February 1st or February 2nd, 2002. She lingered in a coma for several days. Roberson was found guilty of capital murder of a child under 6 in 2003 and sentenced to death. His direct appeal was affirmed, and then he appealed to the U.S. Supreme Court in 2008, 2015, 2016, 2023. They were all denied, including denial of a stay of execution in 2024. He had several state post-conviction claims. Relief was denied in the first, dismissed as an abuse of the writ in the second, denied in the third, and then the fourth and fifth, which were essentially the same as the third, with, quote, new opinions, were dismissed as an abuse of the writ. In federal habeas, he had his relief denied by report and recommendation, which was adopted, and his petition for writ of habeas corpus was dismissed with prejudice. A certificate of appeal was denied, and pending orders not ruled on at that time were denied, and then that was affirmed by the Fifth Circuit. He had an execution date set in 2016, which didn't go forward because of a writ, and I think I have the wrong date for one of those. Oh, no, I'm sorry. I have the right date for the denial, but it was filed in 2016. My apologies, people. And but that was effectively stayed by grant of a TRO by a Travis County court to enforce a legislative subpoena seeking Roberson's testimony at a hearing set for 10/21/2024, and that was granted to the legislators who had issued that subpoena by the Texas Supreme Court. And then on the 24th of October 2024, one of the legislators, Jeff Leach, sent a text to one of the Texas Court of Criminal Appeal judges saying there was basically an improper ex parte communication by Leach to a member of the TCCA in an effort to influence the judge to change her position and grant Roberson a new trial. On the 15th of November 2024, the Texas Supreme Court issued an opinion denying mandamus relief to the legislatures, basically finding that that was an improper procedure to halt an execution and it should not be tried again. And that superseded the grant of mandamus relief on October 17, 2024. So that reopens the door for Roberson's execution, but to date, a new date has not been sought by the prosecutor in Anderson County, Texas.
Is there a reason why they just kind of delay that? Why they don't? Is it just backlog?
Well, it could be a backlog. It could be the judge who had granted the last order recused herself, and that may have been. I don't know why it just may not have come. It may be on somebody's list of things to do that it just hasn't gotten done yet.
Makes sense.
But it's ripe now. And so hopefully the prosecutor will go ahead and seek it now. Unless she's getting pressure from people in the jurisdiction who don't want her to get it reset. I don't know. On the 19th of November, the House Legislative Committee issued its Criminal Jurisprudence Interim Report for 2024, which devotes 17 pages to a one-sided summary of the case against Roberson in the course of his post-conviction litigation claims, which ignores the trial court and TCCA factual findings and legal conclusions regarding those claims, because most of those claims have been rejected by either the trial court and or the Court of Criminal Appeals. They issued a new subpoena to Roberson on December 17th, 2024, to order the TCD, Texas Criminal Justice Department. I have those initials mixed up. To produce Roberson to testify at a hearing on December 20th, 2024. The TDCJ filed a motion for protective order in Polk County, which is, I think, where Roberson is being housed at this time. And so he was not produced, and the hearing went forward. But it was the second one-sided hearing held by the Texas House Committee regarding Roberson's conviction. On the 19th of February, he filed a subsequent application for writ of habeas corpus under Articles 11.071 and 11.073 and suggestion to reconsider on the court's own initiative. That was filed in the Anderson County and in the TCCA. And, pardon me, Kyle got kicked off. Oh no, hopefully he'll be back soon. The claims are nearly identical to those raised in the 04 and 05 writs, which were rejected by the Court of Criminal Appeals in September and October 2024, and relying on additional expert opinions regarding Nikki's cause of death and her autopsy, offering new character evidence and the conclusions in the legislative interim report, as grounds for a new trial for Roberson. And most of that was a result of the one-sided hearing held on October 21st, 2024, and an earlier hearing held on the 16th. Basically, his claims for relief are that he's entitled to habeas relief because he's actually innocent, and that's been rejected time and time again. That he's entitled to habeas relief under Article 11.073. That was rejected in his 2016 writ, and all of the 11.073 evidence that he presented was found to be insufficient. Roberson has been deprived of a state-created liberty interest in violation of federal constitutional law. I don't think that one's going to fare any better. And then he alleges that the court has been misled about the record, which is laughable. The only misleading about the record is from Roberson, and that there was and is no credible evidence that Robert was a person capable of hurting anyone. So this is new character evidence that, like Teddy's sister saying, I never saw him hurt Nikki, and I saw Nikki loved him very, very much. I never saw him be mean to her. And basically trashing poor Teddy's character.
And none of that was brought out in the trial, right?
Well, Teddy testified and Teddy's daughter testified to instances in which Roberson abused Nikki. I mean, again, they're trying to paint it as he was this father who, wanted his child in his life. What I understand the fact is that his mother wanted him to have the child in his life because I think she wanted the child in her life.
Right.
Because I believe he had lost his 2 children with his first marriage because he abused them and he abused his wife. But she came to live with him in November and she's dead in February. I mean, come on. And they keep making her sound like she was sicker than she was at the time she died, and that she died of some blood clotting disorder. And that's why there was all the bleeding on the brain. And that the medication that was administered to her is what caused her death. And it's like all of that could have been developed because all of it's based on information that was available when Dickie died. It could have been developed at trial and presented at trial. It could have been developed in his first habeas and presented then. And I mean, he's had federal habeas as well, which I think I skipped over on this one, but he's had federal. Oh no, I had federal habeas. Never mind. But he's presented that in federal habeas. And I think he's tried to re-present it at one point. So anyway, the Innocence Project of Texas has also filed an amicus curiae brief on regarding a suggestion to reconsider denial of application on the court's own initiative. And that's been filed in the 03, 04, and 05 actions. So that's pending. There's been no response by the Anderson County Court. A judge has been appointed in the Anderson County Court, but it's up to, at this point, the TCCA to decide whether any of these claims are worthy of remand to Anderson County for development. So that's where we stand on that. And of course, as soon as that happens, I will let you know. Again, as with Hanson, if there's any development, I will definitely talk about it outside of a update episode. All right. Any questions on Roberson?
No, do you have any thoughts on the idea that the shaken baby syndrome has sort of been, like, there's, I guess, maybe some quote unquote controversy around it? I don't know enough to say whether it's real controversy or sort of manufactured, but
as of 2024, it's not as controversial as Roberson's attorneys keep saying it is. There was a case called Ex parte Rourke, where his conviction was reversed. But in his case, it was entirely shaken baby. In Nikki's case, Nikki's cause of death was blunt force impact, blunt force trauma, and multiple blunt force trauma was documented in her autopsy report and in the testimony at trial. And the juror who appeared at the hearing on October 21st, who says it was all shaken baby, just doesn't remember very well, because it was not all shaken baby. Shaken baby was mentioned. It was believed to be a component or a potential component to Nikki's injuries. But Nikki had a mark on her face. That is blunt force impact.
Got it. That makes sense.
Nikki had bleeding on her brain, which was attributed to blunt force impact because she had a soft spot. Now, yes, she didn't have skull fractures, but they're also arguing that, well, she could have lost consciousness and fallen, and that could be what caused the injury. Roberson has claimed that Teddy's sister came by to do drugs with him and have sex with him that day, and that she got mad and she shook Nikki and then threw her down on the floor. And he claimed that in 2007 in a filing that he made to the Court of Criminal Appeals. So that is trauma. That is blunt force impact. That is not shaken baby.
Shaken baby.
You know, so Nikki's cause of death was blunt force. Nikki's cause of death was injuries to her head, not shaken baby. Again, it was believed to be a component, or potentially believed to be a component, but it was not the sole thing in her. In fact, I don't think her autopsy report mentioned shaking at all. And a lot of the testimony that they cite were based on questions asked of the experts and of the doctors by the defense. So it's just they're misleading the public when they claim it was a shaken baby case. All right, so now we go to Texas versus Rodney Reed. Victim was Stacy Lee Stites, age 19. Rodney Reed murdered her on April 23rd, 1996. He was convicted of capital murder, 2 counts, on May 18th, 1998, and sentenced to death on May 28th, 1998. His conviction and sentence were affirmed on direct appeal on December 6, 2000. He had an initial state post-conviction claim filed on November 16, 1999, and he raised multiple claims for relief. I actually was able to get a copy of those findings of fact and conclusions of law. But I'm not going to go into everything here. But a lot of the claims that he raised were similar to the ones that he's raised over and over again since then, including actual innocence, prosecutorial misconduct regarding arguments at guilt innocence, and failure of his counsel to put on evidence of a relationship between Reed and Stacy, lack of meaningful appellate review, and constitutionality of habeas corpus procedure. He also raised the suppression of exculpatory evidence related to the May 13, 1998 lab report regarding the beer cans, not bear cans. I don't know how I did that and didn't see it.
This is the case that makes me crazy, that anybody actually could, with 2 functioning synapses, could think he's innocent.
Well, it's because they're being misled and led to believe that the DNA evidence is a few old sperm cells. When it's, when it's on her breast, in her body, in her underwear, on her pants, on her back brace. A writ issued from the TCCA on February 23rd, 2000 The state answered on June 23rd, 2000. The court issued an order on September 5th, 2000, finding there were no unresolved controverted issues of fact in applicant's case, that an evidentiary hearing was not necessary, and the parties were to file proposed findings of fact and conclusions of law by October 5th, 2000. Those findings were filed by the state, and Reed filed a motion for, supplemental motion for an evidentiary hearing. The state responded. That was in October and December. An evidentiary hearing was granted on January 10th, 2001, and was held on May 15th, 2001. On October 1st, 2001, the conclusions of law, a 71-page finding of fact and conclusions of law was entered. There are 424 findings of fact and 87 conclusions of law, and I will be posting that on the Rodney Reed is Guilty site. The court concluded that applicant has procedurally defaulted on his second, third, fourth, sixth, and seventh, subsection C, 8th, 9th, 13th, and 14th claims for relief by not raising them on direct appeal. His fifth, seventh, subsections A and B, and 12th claims for relief are not cognizable because they have already been raised and rejected on direct appeal. His third, fourth, fifth, sixth, seventh, subsection C, 9th, 12th, and 13th claims are not cognizable on collateral view, as the question of a trial court's decision on the admission of evidence is subject to a harm analysis. Applicant's seventh, subsections A and B claim for relief is not cognizable on collateral review, as the question of a trial court's ruling on an objection during jury argument is subject to a harm analysis. And it found ultimately that applicant has failed to demonstrate that he's actually innocent of the capital murder of Stacey Stites, and he's failed to demonstrate that his conviction was unlawfully obtained. Accordingly, it is recommended to the Court of Criminal Appeals that relief be denied. He has appealed to the United States Supreme Court multiple times. His initial appeal on his conviction was denied on October 9th, 2001. His appeal of his federal habeas denial was denied in 2014. He had a writ denied in 2020 with a dissent by Justice Sotomayor. On April 19, 2023, he had a writ granted, and that judgment was reversed in a 6-3 decision with 2 dissents, and that sent a federal challenge to Texas DNA testing statutes back to the Fifth Circuit Court of Appeal, where it is still pending. And then his latest writ was denied on July 2nd, 2024, and that was an appeal of denial of his 2023 state post-conviction writs 10 and 11. He's also filed a subsequent writ of habeas corpus at the Fifth Circuit, which was a permission to file a successive writ, which was dismissed without prejudice, pending resolution of Reed's claims by the Texas Court of Criminal Appeals. That was on November 14, 2019. Now, Reed versus Lumpkin, which is a motion for relief for judgment, motion for discovery, was dismissed for lack of jurisdiction on September 30th, 2023. Reed versus Getz, which is the federal appeal at the Fifth Circuit Court of Appeal that was remanded by the U.S. Supreme Court. Oral argument was held on that on September 23rd, 2024. A decision is pending on that. Reed also filed a request for permission to file a successive writ at the Fifth Circuit in docket number 24-50529. That was dismissed denied on November 5th, 2024. So he has, the only thing he has pending now is the Fifth Circuit state law DNA challenge. It is not going to decide that he's entitled to DNA testing. It is not going to remand the case back to the state court to grant DNA testing. It's merely going to decide whether you can proceed with a civil rights challenge in federal court. And that's where his case stands right now.
It seems like the innocence fraud noise around him has really died down, or maybe it's just me, but it seems like even this is one of those cases, even a lot of people that are hardcore fraudsters are even a little bit suspect to get too excited about him.
Well, I don't know, because, every time he files something new, it gets the same treatment of the system's unfair, and, he's being discriminated against because of his race, and, all that stuff. It's just there's not a lot of noise right now because
It's been quiet.
It's been quiet because there's nothing to report. But of course, if you look in July, when the U.S. Supreme Court denied his latest writ, we had a lot of noise about it in July. They're not catching on like they didn't catch on the successive writs, but I think that's because they haven't been presented with the successive writs of the motions for relief to use those as a vehicle to lie about the case. So
Where does he stand now, though? Just like as a quick summary, has he got any open appeals, or?
Well, he has that one at the Fifth Circuit that was remanded by the U.S. Supreme Court on the civil rights claim.
So just waiting on the.
And once the Fifth Circuit decides that one, they can seek another date.
Got it.
They could theoretically seek another date now because this is an extraordinary remedy. But I think that they're just not gonna try seeking a new date until he's exhausted everything and everything's been decided. But that's not to say when they get a new date, he's going to file another state writ, and he's going to have some more witnesses that claim Jimmy Finnell confessed, or more witnesses that say there was a relationship between Rodney Reed and Stacey Stites, and maybe some Brady claims. Maybe they'll find some notes somewhere, and they'll claim the defense didn't have those notes, and they'll try to do a glossip and invent a constitutional violation.
Right.
Because apparently Judge Kavanaugh, he's pissed about something because he's not acting like a true conservative in a lot of the decisions he's been making. So I don't know what's going on with him. Because he's been the conservative that's been joining the liberals in a lot of these cases. So we'll have to see how that goes. All right, next is Texas versus Melissa Lucio. Her victim was Mariah Alvarez, 2 years and 5 months. She was killed on February 17, 2007. Lucio was convicted on July 8, 2008, and sentenced to death on July 10th. The dates may be approximate. I don't think the dates are correct. Her direct appeal, her convictions and sentence were affirmed on September 14, 2011. Her writs to U.S. Supreme Court in 2012 and 2021 were both denied. She has had multiple state post-conviction writs. For some reason, I only have her fifth and third. Missing some on that one. And she's also gone before the gone to U.S. federal court with a petition for writ of habeas corpus. And her case was remanded after granting a partial COA on a complete defense claim in 2019, but then on en banc review reversed that decision and affirmed the district court's denial of relief in 2021. That's what was appealed to the U.S. Supreme Court. update on remand, her case went back to the trial court in 2024 from the Texas Court of Criminal Appeals. The parties entered agreed findings of fact and conclusions of law that the court concluded that applicant has met her burden of proof by a preponderance of the evidence that she would not have been convicted in light of the suppressed evidence. The court concludes that applicant is entitled to habeas corpus relief from her conviction and sentence in this cause under Article 11.71 as presented in Claim 5. That was in April of 2024. On June 19, 2024, the TCCA remanded the case back to the trial court. Accordingly, we remand this cause to the trial court. Within 90 days of the date of this order, the trial court shall make findings of fact, conclusions of law, and a recommendation addressing each of applicants' initially remanded claims on the merits. The district court clerk shall then immediately forward to this court the trial court's findings and conclusions and the record developed on remand. That record should include the reporter's record of the hearing, if any, held on the parties' agreed findings, as well as the reporter's records of any hearings on applicants' remaining remanded allegations. If no such hearing on the parties' agreed findings was held, the district court shall verify that to this court in writing. Any request for extensions of time or of the time period set forth above shall be made by the trial court or on its behalf and directed to this court. On October 16, 2024, the trial court entered additional agreed findings of fact and conclusions of law. And this is what happened. The trial court and the parties agreed on Claim 5 to grant Lucio relief. And so that findings of fact was entered, and it went back to the TCCA. Well, the TCCA was like, excuse me, we sent several claims back. We want findings and conclusions on all of them, not just one of them. And I think what the idea was, if the TCCA didn't grant relief on Claim 5, they could say, well, wait a minute, we can go back now to the trial court and do the other claims. And so the TCCA was not having that.
Right, just trying to prolong.
So basically what happened is the trial court essentially entered agreed findings of fact and conclusions of law, basically granting Lucio relief on all of her claims. Now, I have some trouble with some of the claims. For example, based on statements made by Lucio's children about the fall from the stairs at the old apartment. I'm still kind of finding how statements of Lucio's own children could amount to a Brady violation.
Yeah,
because
that
her
seems pretty
attorneys
crazy.
could have gotten, and this is all the statements from her children, and her statements from her children that she never abused them. Well, of course her kids are going to say she never abused them.
Yeah, exactly.
Either they're afraid of her, or they don't want her in trouble, or, whatever. But, the knowledge of the fall, Lucio had that knowledge. Lucio knew about that. And Lucio knew who witnessed it from the kids, because Lucio was there.
Right.
So, that can't be a Brady violation. And a lot of the grounds are on false confession about challenging the autopsy.
I know I'm being
Dr.
a little
Farley's.
absurd, but I mean, it's not quite as bad. I mean, I'm being a little silly, but it is almost like saying, oh, I didn't get to declare my own innocence and testify, so that's a Brady violation. I mean,
yeah, it's something.
I mean, her kid, she has the best access to them.
Yeah. And, like I said, well, I think the argument is they didn't have these statements to CPS. And so they couldn't impeach them on cross-examination when they testified at trial. Or they couldn't ask them to, make these statements on when they testified at trial. I'm not entirely sure, because what's available are the findings and conclusions, and not, well, they have a lot of declarations from the children too. But anyway, so basically this amounts to her being declared innocent by the trial court. It's back before the TCCA. They've gotten the supplemental records as of November 12th, 2024. And now they can reject it, or they can follow it and grant her relief. So it's still kind of up in the air as to whether they'll reject it or whether they'll grant it. So that's the end of Lucio for now. Now we go to the West Memphis 3 post-Alfred DNA testing. And I have a note in there for myself. My apologies, Kyle. I forgot to delete it when I fixed the formatting. The victims are Steve Edward Branch, age 8, Christopher Mark Byers, age 8, and James Michael Moore, age 8. They were murdered on May 5th, 1993 by Damian Echols, Charles Jason Baldwin, and Jesse Lloyd Miskelley Jr. Miskelley was tried between January and February of 94, and he was convicted. His case had been moved to Corning in Clay County, Arkansas. He was convicted of 1 count of first-degree murder for the death of Michael Moore and 2 counts of second-degree murder for the deaths of Steve Branch and Chris Byers. He was sentenced to life on the first-degree murder charge and 2 20-year terms on the second-degree murder counts. His conviction and sentence were affirmed on direct appeal and became final in 1996. Echols and Baldwin were tried together between February and March of 1994. Venue in their cases was moved to Jonesboro and Craighead County, Arkansas. In March of 94, Echols was convicted of 3 counts of capital murder and sentenced to death. Baldwin was convicted of 3 counts of first-degree murder and sentenced to life without the possibility of parole, and their convictions and sentences were affirmed on direct appeal and became final in 1997. Echols pursued Rule 37 relief in the Arkansas state courts, and denial of his claims by the trial court were affirmed by the Arkansas Supreme Court. His federal writ of habeas corpus was stayed pending the outcome of his motion for a new trial in state court. Baldwin and Miskelley's claims, Rule 37 claims, were pending, and their motions for new trial were also pending. On August 19, 2011, they appeared in court and entered Alford pleas, which allowed them to claim to be innocent while entering what are legally and factually guilty pleas. On June 28, 2022, the trial court in Crittenden County denied Echols' request for post-conviction DNA testing. On April 18, 2024, the Arkansas Supreme Court reversed that decision with a dissent by Justices Womack, Webb, and Special Justice Marcia Hernsberger. And testing was supposed to begin as of February 26, 2025. The reports regarding DNA testing are all over the place, and as usual, no one has their story straight. Echols has posted on social media that the current prosecutor has agreed to testing and that it would begin before the end of 2024. He's later posted that testing has been delayed for unspecified reasons and has given no indication of when testing would begin. Lonnie Sori has given interviews that suggest that they want to expand testing beyond the ligatures as originally requested by Echols. That would likely require court approval, and to date, no motions have been filed in either Crittenden or Craighead counties seeking court approval of any DNA testing. While it's possible for the parties to agree to testing, it is unlikely in reality. So my suspicion is that Echols hasn't filed anything or asked the court for anything. The last thing filed has been the mandate, which was filed in May of 2024.
Well, and it's a couple of things. I think it's important to note, like on the Alford plea, I don't think a lot of people realize that they asked for the Alford plea. Once they got the original DNA results back, which to my knowledge have never been released, once they got those, and I believe you can see this at the end of the first Paradise Lost movie, then they suddenly decide, oh, never mind, let's don't continue to appeal. Let's ask for an Alford plea. And I mean, I think it's important for the people to remember that they because there's a whole group out there, as you know, that think that this magical DNA will exonerate them, but there's DNA out there that they have refused to release the results. Isn't that correct?
And when you look at it, the prior DNA testing was inconclusive.
Right.
I mean, inconclusive. There were multiple things that were tested that yielded absolutely zero DNA. So there's no meaningful comparison for some items of evidence.
Right.
Now, Bob Ruff got this wild idea that MVAC is going to be the solution. But MVAC is an evidence collection method. It's not a testing method, and it doesn't guarantee, it's not going to recover DNA where none exists.
Right, exactly. Well, and there's so much
can recover smaller amounts of DNA, but a lot of this evidence didn't yield any DNA in the first place.
Right.
So.
Well, and they harp on, the hair, but they kind of the folks that are pro-child killer, they sort of harp on the hair, but they ignore some of the other DNA, which again, it's not conclusive, but it is as conclusive as the hair that they claim was one of the stepfathers, which would make sense. I find hair from my kids on my shoes and on my clothes all the time. That's the way hair works. It's not shocking.
There was one result that did not exclude Echols, Baldwin, and Miskelley. It was inconclusive.
Right. Exactly.
But the alleles on that evidence were possessed by Echols, Baldwin, and Miskelley. So it could be a mixture.
Right. And that's the thing. It's like, that's fine.
And I think personally, I think that's why they went for the Alford pleas.
Oh, absolutely.
Because if they're not excluded by one item, that's the end of their new trial motions.
There's something in those DNA results that they refuse to release that I think clearly points to their guilt. Like, I think they found one of the killer's DNA.
Yeah.
And that's why they magically refused to, oh, never mind. What DNA?
I don't know where it is. I misplaced it.
Oh,
well, the prosecutor has it.
DNA thing of which you speak.
And that's the thing too, is I don't believe that Scott Ellington had the full DNA results.
No,
because if he did,
I don't think that's disputed, right? I don't think we know
for letting him enter Alford pleas. I would have said, let's see what happens at the new trial hearings.
Right.
If new trials are granted, we can revisit this.
Absolutely. Yeah, I just think that DNA is such a smokescreen. And I think too, I think for this is probably, we've seen this before, everybody's really forgotten about them, largely except for a few wackadoodles online. And so they're not getting, has Echols ever had a job? I think his gravy train of donations is drying up. And whenever his bank account gets low, he starts on social media about, these new developments. If you'll just send a little bit more money, then we can find the real killers.
Yeah. Yeah. Anyway, all right. So, moving on, we have North Carolina versus Molly Martins Corbett and Thomas Martins. Their victim is Jason Paul Corbett, who was murdered on August 2nd, 2015. They were convicted on August 9th, 2017 of second-degree murder. Corbett was sentenced to 20 years minimum and 25 years maximum, as was Thomas Martins. On February 4th, 2020, their direct appeal. Their convictions were reversed and the case was remanded for a new trial. On July 8th, 2020, Sarah Corbett Lynch, who was age 13 at that time, published a book entitled Noodle Loses Dad, Exploring Loss, Blended Families, and Grief, which is pretty freaking impressive. And this is planned to be a series. I don't know whether she did subsequent books in the series, but you can find them on Amazon. And then on May 12th, 2021, the judgment of the lower appellate court in North Carolina was affirmed by the North Carolina Supreme Court. And so then Corbett and Martin's cases went to retrial proceedings. On October 30th, 2023, they entered pleas. Corbett pled no contest to voluntary manslaughter, and Martin's pled guilty to voluntary manslaughter. That is not what happened to Jason Corbett, but with the potential entry of evidence from Jack and Sarah, which were lies that they were encouraged to tell by Molly Martins, the state, I think, wanted to cut its losses and let them plead. But they committed murder. They drugged Jason and then they beat him to death. They were sentenced on November 8th, 2023. Corbett was sentenced to 4 years and 3 months minimum and 6 years, 2 months maximum. Martins was sentenced to 4 years and 3 months minimum and 6 years, 2 months maximum. Sarah gave a victim impact statement on November 8, 2023. She said, "I was 12 weeks old when my mother, Mags, died. I was 8 years old when my father was killed by Molly and Thomas Martins. The Martins made me an orphan. They took away my father, my only constant, the only loving parent I had." And anybody who listened to our show, remember Molly Martins wanted Jack and Sarah to continue to live with her and for her to be their mother.
Yeah, this was just one of the horrible cases. I mean,
yeah,
Molly's a true nut job.
Luckily, their Aunt Tracy and their Uncle David prevailed, and Sarah and Jack have gone back to Ireland. They were raised by their aunt and uncle with their cousins, and they are both they're both into music. And Sarah is an accomplished singer, dancer, musician, as is Jack. Jack's an accomplished musician, I believe. He's pursuing like a college, and she's, I think, just graduated. They're both very, very amazing kids, considering everything that they've gone through.
Especially exactly considering what they had to go through.
On June 6, 2024, Martins and his daughter were released due to credit for 44 months served prior to reversal of their initial conviction. On that date, Sarah Corbett Lynch issued a statement saying, "The sentence disappoints me. I'm doing the best I can, but I feel let down and disappointed by any outcome where the Martins are released back into society. It feels unjust that they weren't brought before a jury of their peers. I am confident they would have been found guilty, evident by their acceptance of the plea deal. Molly Martins manipulated my love, trust, and feelings from a very young age for her own gain. The Martins chose self-interest over considering the harm caused to innocent individuals, especially children. But I am no longer a child that can be manipulated. I aim to prevent such situations from happening again. Despite serving their sentence, the repercussions of their actions will have a lasting impact. The truth known by all involved will eventually come to light for the world to see." The Corbett family issued the following statement. "After a 9-year battle for justice, we are deeply disappointed by the impending release of Tom and Molly Martins, the individuals responsible for the senseless and brutal murder of Jason, leaving his 2 children orphaned. Jason was drugged and they beat him with a brick and a baseball bat while he was unable to defend himself. They left the room without a mark on either of them. The heinous actions of Tom and Molly Martins not only took Jason's life in a malevolent, cruel, and vicious manner, but they also set about to tarnish his reputation and use his children in a self-serving attempt to evade accountability. Molly Martins relentlessly put Jack and Sarah into the center of her bid to evade justice with a web of lies while refusing to take the stand to give evidence herself. Her cruelty, disregard, and treatment of two children under 10 years of age whose birth mother had died, fathers she had just battered to death, and whom she professed to love, was inhumane. Despite the gravity of their crime and the immense loss they inflicted, they will be free today after serving just 4 years and 3 months. Their lack of remorse for the irreparable harm caused to Jason's children, whom they callously orphaned, is a stark reminder to all of their callous disregard for human life and decency. Throughout the protracted legal proceedings, they prioritized their own interests over the profound suffering they inflicted upon innocent children. Justice is twofold for criminals like Tom and Molly Martins. While they may have completed the court-mandated sentence, they now carry the enduring burden of their actions, forever knowing they extinguished a noble life. We know the truth, they know the truth. Soon the world will know the entire truth. Their legacy is one of undeniable guilt exposed to an intelligent public who, when they look at the facts and evidence, acknowledge their malevolent deeds on August 2nd, 2015, without the shield of legal technicalities. As Jason's family, we vow to tirelessly uphold his honorable legacy and seek justice to preserve his memory. Amidst this somber occasion, we draw solace from witnessing Jack and Sarah, the remarkable children Jason left behind, blossom into exceptional individuals he would undoubtedly be proud of. Our heartfelt gratitude extends to the unwavering support from the communities of Davidson County in North Carolina and Limerick, Ireland, who stood by our side throughout this harrowing ordeal that no family should endure. We remain resolute in our pursuit of truth, justice, and the protection of Jason's cherished memory.
And remind me, they just killed him because was he threatening to divorce her or take the kids?
Yes, he would not let her adopt Jack and Sarah. He was threatening to go back to Ireland. He was actually, I think, planning to go back to Ireland.
That's what I remember.
He had planned a trip, and he didn't want Molly to go with him. And I think he was planning the trip to go back to Ireland and move back there permanently without her. So, and then finally, in this case, Sarah Corbett Lynch has authored a book entitled A Time for Truth, My Father Jason and My Search for Justice and Healing. It has a U.S. release date of March 17th, 2025. It's currently available in hardback in Ireland and possibly Europe, or at least Ireland and the UK. But it's also available now on Amazon Kindle. And it's Sarah's been making the rounds, and so far the book is getting, really positive reviews. I'm certainly going to download it on my Kindle probably tonight and start reading it.
Awesome.
So, but it deals with, her memories from an 8-year-old through now. So that's basically the Corbett case. And so now we have just a few more that there's really not a lot going on, but I figured I would just kind of update where they stand. And there are some cases I'm not even going to mention because there's literally nothing. It's crickets on those cases. First, we have Arizona versus Jodi Arias as of February 13th, 2025. She has not yet filed a petition for post-conviction relief in state court. She is trying still to obtain documents, and there is a status conference set, or there was a status conference on February 21st, 2025 on her request for documents. Florida versus Dahlia DiPolito, as of February 27th, 2025, her federal habeas claims are still pending in U.S. District Court. There's been no further action or new filings since her reply brief was filed on October 10th, 2023. Tennessee versus Janet Hines. She is still incarcerated at the West Tennessee State Penitentiary in Henning, Lauderdale County, which is near Memphis. She has not filed state post-conviction claims as of this time. Oklahoma versus Julius Jones. Victim was Paul Howell. Victim Travis Alexander. Victim Michael DiPolito. Victim Nicholas Gallagher. Victim Paul Howell. On August 1st, 2024, Christopher O'Neill Jordan, Jones's co-defendant, was charged with 2 counts of assault with a dangerous weapon and threatening violence arising from a 7/24/2024 assault on an Oklahoma natural gas worker in Oklahoma City. And Jordan is set for a competence review on March 4th, 2025. Maryland versus James Kulbicki. Victim is Gina Nielsen. On October 22nd, 2024, jurors convicted Kulbicki of first-degree murder. Jurors spent less than half an hour deliberating Tuesday before delivering the same verdict as the juries that heard the 31-year-old case in 93 and 95. They also found Kulbicki guilty of using a handgun in commission of a felony. Sentencing was set for February 25th, 2025 in Baltimore County Circuit Court, and I didn't check the docket to see what happened with that, but he's going to direct appeal, so we'll update later once that process concludes. Texas versus Romeo Pinkerton. Victims Opie Hughes, Joey Johnson, Monty Landers, David Maxwell, and Mary Tyler. The KFC murders. On July 16, 2024, his parole was denied. His next review has been set for July of 2029, and he remains incarcerated in the Allred unit in Iowa Park, Texas. And then finally, Texas versus Henry Watkins Skinner. Victims Twyla Jean Busby, Randy Busby, and Elwyn Kaler. On February 16, 2023, Skinner died as a result of surgery in December of 2022 to remove a brain tumor. There were complications, and he died in a Galveston, Texas hospital. So that's the end of our updates. The rest of the cases, again, had nothing new going on, nothing even worth reporting. So
Excellent.
That's our updates for season. Excuse me. That one came out of nowhere, people. So, and then I've got the docket so far, the list so far for season 4. We are, of course, going to look in more depth at Glossip. And I'm trying to line up guests who can address the impact of the recent decision on the family of Barry Ventries, because in the end, that's where the most harm is being done. I'm going to do the criminal procedure primer, since we didn't really do that one for Based in Fact. So that's going to be fun preparation. And then I'm planning on, Wisconsin versus Dassey and Avery, State of Florida versus Ziegler, Michigan versus Frederick Freeman, aka Temujin Kinsu, Missouri versus Charles Erickson, Florida versus Ashley MacArthur, which is a really interesting case, and California versus Scott Lee Peterson. And then I also want to go ahead and do another Supreme Court review of the cases that we missed when we did the prior review. and the
Gotcha.
post-2010 cases.
Sounds great.
So, so that's going to be what we're looking at. And of course, feel free to post on YouTube, post on Facebook or Twitter with any suggestions that you all have. Although my one caveat it's got to be a case that's gone through court proceedings, direct appeal at least, because my basis for research is the appellate opinions, not what
the trial
somebody
transcript
on the internet
right
says the facts are. I mean, I will consider those facts, but my basis for facts are developed in the appellate and the court records. So, and that's basically it.
Well, sounds good. Thanks for all your work again. Have a great rest of your week. Enjoy Mardi Gras on Tuesday.
Well, I as I told my bosses when I asked for Monday off, I said I'm not leaving my house. I will not be out partying, I promise. So, thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans. If you like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'BrienLN. Kyle and I will return in 2 weeks for episode 4, State of Oklahoma versus Richard Eugene Glossip. We'll talk about the Supreme Court's decision vacating Glossip's conviction and remanding for a new trial and the impact of that decision on the Van Treese family. Until then, have a safe 2 weeks. Night.